This is immigration attorney Misbah Chaudhry. I hope all the viewers and listeners are doing very well. Today I want to discuss a little bit of difference between investment visas of two types. One is the E-2 and the other one being EB-5. What is the difference? What are the pros, what are the cons if you are trying to do one from another? What are the options available? So we will briefly discuss all of those. Lots of videos I've seen, people are putting in, attorneys, non-attorneys, about the EB-5 in media. First of all, please make sure that all the listeners know that the legal advice for immigration can come only from an attorney, and that is the most sourceful advice which you can rely on. Secondly, very importantly, what is the comparison between the EB-5 and E-2? There is a big comparison and there is a big difference between the two. Why one will take one option and the other can have the option available and go with the other kind of investment. To be very open, to be very simple about explanation, is that the E-2 falls under the treaty investment visas, which is the treaty between United States of America and certain countries. Now those countries are from all around the world, and their number can change from one year to another. Some countries are included in, some countries are taken out, like Nigeria most recently, a few years ago, has been taken out from the list of the E-2 investment countries. So the natives or the nationals of Nigeria do not qualify under the E-2 investment category anymore. There are many countries, close to 68, 69 countries, which are in treaty with the United States of America, and the nationals of those countries can apply, do the investment in the United States and can apply for the E-2 visa, and later on which can lead to the green card process, and they will be able to get the permanent residency status in the United States. So compared to the EB-5, what is the difference? The biggest difference is the amount. The countries most likely which are like India, nationals of India and the nationals of China, who are not the members of the E-2 treaty, investment treaty countries, and they do not qualify for the E-2 category. So they have somehow, and if they are investors and they want to invest in the United States, they can only take the option for the EB-5. Now EB-5 is the biggest difference is the amount of the investment. When you talk about EB-5, you are talking about the big investment of close to starting from 900,000 to 1.5 million, which is a very big amount as compared to the investment which is required for the E-2 visas, the E-2 qualified visas. That investment should be substantial amount and can be based upon the worth of the business, what business you are buying, your percentage of interest in the business, that is your shareholding in the business, should be more than 50% in the business, total worth of the business is involved, and which is very convenient for these nationals of these countries who are eligible to apply for the E-2 to easily apply for E-2, get the E-2 status, and can do the businesses, conduct their business, make investments in the United States, and can generate revenue and go on with their businesses in the United States. As compared to EB-5, the regional centers are mostly involved in these kind of cases. And the investment amount is so big that mostly the two countries which are not in the E-2 treaty, investment treaty, get involved into these kind of visas, which is India and China on the most. So this is the biggest difference when we talk about the EB-5 and the E-2. E-2 is the most convenience. It leads to more or less the same timeline. Number two, it leads to green card. Directly you are or indirectly, the people who are eligible for E-2, they become eligible for the green card as well under certain requirements and under certain options they can adopt. Number two thing is that EB-5 being such a big amount, where you are doing the investment, so the more risk is involved on that. In our law firm, we are a complete immigration law firm. We practice all kind of cases throughout the year, which includes the EB-5 as well as E-2 and all the other kind of visas and petitions that we file, family-based as well as employment-based work visas from our law firm. So giving that comparison is just to give a clear picture when people are trying to make a decision on that what they need to decide, whether they have that amount of money available, whether they have to wait to gather all that money and waste so many years on that, or if they are eligible for E-2, they can move forward with their so many other options for the investments, do the E-2 visa done, and can move on with their business opportunities and their business plans within the United States of America. So you need to know more information about this issue. You need to know more clarity about this issue. If you think that you qualify for E-2 or if you qualify for the EB-5 category, contact us. Our number is on the screen. Our information is on the screen, where you can easily find. Our website is there. Our media information is there. We are here to help you. We mean immigration. Misbah Chaudhry and Associates, Immigration Law Firm. Thank you.